Hello, good afternoon, everyone. Warm welcome to this webinar on Indonesian families. We're going to just run through very quickly some of the upcoming webinars or virtual roundtables that will be held during the course of June, and after which I'm going to hand over to Joe Tang, who will then kick things off and take us through the virtual roundtable for today. So if I just share my screen and take you through what's planned for the upcoming days ahead. The first one will be tomorrow, which is the China Private Client Virtual Roundtable. If you've not registered for this, then please spend some time. It's on LinkedIn, or alternatively, you can email me and I'll be able to direct you to the relevant registration page. Now, later in June, we're going to have the first Thailand Virtual Roundtable. Dates are not confirmed yet, and we're probably going to be joined by a Japanese legal counsel for this one, but this is in the current, it's sort of in the details being worked out in the background. And then later on still, we will have finally the Malaysia Private Client Virtual Roundtable, and Lab 1 IVFC have been invited to contribute to this with us, and of course Henley and Partners will join as well. So these are the upcoming virtual roundtables. I think that the key one is tomorrow for the China Private Client, because that's confirmed, and that'll be at 4 p.m. Tomorrow, Singapore time. Basis of these virtual roundtables is pretty consistent. What they're looking at is the interaction of the different legal systems. So we have clients from around the region, and we're looking at how their legal systems interact in a number of different ways. So we're looking at it from a perspective of community property, where there's relevant laws, and we're looking at it from a perspective of the clients divorcing, as well as looking at it from a succession standpoint. And really the important aspect from, let's say, Singapore or Hong Kong sort of financial services sector perspective is that we're understanding really the limits of the private wealth structures that we promote to our clients, and also understanding what can happen with their private wealth if these circumstances were to arise on a divorce, and particularly because of the COVID-19 problems, looking at succession in particular. So, as I say, China's coming up. The dates for the programs in Thailand and the programs for Malaysia will be announced in due course. The same thing, we're looking at an interplay of the relevant jurisdictional laws and seeing how those interact on a cross-border basis. Okay, I'll stop sharing now, and I'll invite Joe to take over from here.
Thanks, Zach.
Okay.
Zach, in the meantime, can you try to get
there we are.
Freddie in? Yes, there he is. Excellent. So let me share my screen. Okay. All right. Can you guys, Zach, can you see my screen?
Yeah, so it's in presenter mode. You just need to switch to that other mode that we were doing earlier on.
Yep. Is this the one correct now?
Nope, not yet. Just keep going. Not yet. Keep going. If you want, I can just do it, Joe.
Yep, it still doesn't work, right?
No, so I'll do it if you wish.
Okay. Let me just stop sharing.
Okay, here you go.
Okay, so we're all in. We're good to go, I guess.
Yes.
All right. Thanks, Zach. So let me first start by introducing the speakers today. Freddie, I'm glad you're in. Freddie Karyadi is a partner at ABNR, a very prominent Indonesian law firm. Freddie has over 20 years of experience practicing law in Indonesia, and he has been assisting and advising Indonesian business families and high net worth individuals with structuring transactions and assets, mergers and acquisitions, divestments, and of course with the tax amnesty. Freddie has been consistently rated as one of the leading lawyers by several international publications, including Asia Law, Legal 500, Asia Business Journal, and the IFLR 1000. And this is over the past decade. Next, I would like to introduce Zach. Zach Lucas is a partner at McCarthy Denning. Zach is a qualified, UK qualified lawyer with over 20 years experience in private client practice. He's been advising high net worth individuals and families in relation to international wills, trusts, and estates, with a particular expertise advising on cross-border succession and international matrimonial rights and remedies. Zach currently splits his time between London and Singapore, and he's leading McCarthy Denning's partnership with the local Singapore law firm Arrogates LLC. Zach is a former partner of various international law firms, and he was previously admitted to practice law in the BVI and Anguilla. Next, I'd like to introduce you to John Shoemaker. John is a registered foreign lawyer at Butler & Snow in Singapore. John has over 25 years experience, which includes US tax and regulatory law, multi-jurisdictional compliance issues globally. John is a seasoned professional in international wealth transfer planning. He represents ultra-high net worth families and family-controlled businesses throughout the world with respect to US federal income, gift and estate taxes, especially as they apply to trusts, foundations, and other fiduciary structures. He is a frequent presenter on cross-border US tax issues. His extensive understanding of US estate succession and related community property laws, combined with a background in regulatory issues of compliance management, gives him a unique insight into managing and controlling risk and structuring fiduciary products in a highly efficient and compliant manner. Finally, I would like to introduce you to Dominic Volek. Dominic is the head of Southeast Asia at Henley & Partners in Singapore. Henley is one of the leading migration firms in the world. Dominic is responsible for Henley & Partners operations across South and Southeast Asia. Dominic is a private client specialist in residence and citizenship by investment planning, and regularly advises high net worth individuals, their families, and advisors across Asia, targeting countries that are deemed most attractive to wealthy clients in terms of mobility, security, privacy, personal tax, estate planning, as well as lifestyle. Dominic is a member of the firm's government advisory practice, providing strategic advice to governments on the design, implementation, and promotion of investment migration programs. Next slide, please, Zach. So the agenda of today, we prepared 3 case studies for you. We'll be looking at domestic matrimonial property for Indonesians, issues surrounding divorce and succession. Then we'll be looking at foreign matrimonial property for an Indonesian, and we'll go over the same issues with respect to divorce and succession. Finally, we'll have a few on the Indonesians migrating to the EU and some of the considerations there. Next slide, please, Zach. So the first case study, we have an Indonesian couple. You can see in the middle Rudy, who's married to Katrina. They're Indonesian citizens. The domicile is Indonesia, and they're living in Indonesia. So before we move on, Zach, since we got a very diverse audience today with many guests from a common law background and many guests with a legal background. Can you briefly explain yourself, please?
I think, Joe, sorry you broke up, but I think what you're asking is in terms of domicile and how that works. So from a domicile perspective, it's really a common law approach to classifying the status of individuals. So domicile is a rather nebulous little project or topic because it actually comprises many different aspects. One of which is you will get a domicile of, if you're from a common law jurisdiction, you'll generally have a domicile of origin, which is usually your parent. So your father, if your parents were married, your mother, if you were unmarried. And then later on, you'll have a domicile, effectively of dependency as you grow up. And once you reach majority, you're then able to have choices as to different jurisdictions in which you can then take on a domicile of choice. The key thing is you always have a domicile, one single domicile throughout your life. And the challenge with domicile of choice, which is generally the most difficult, is showing enough connecting factors to a jurisdiction to justify having a domicile there for common law systems. Many of the legal sort of constructs around succession, around matrimonial regimes, etc., deal with domicile. And so domicile as a concept tends to be quite an important topic to understand when you're looking at succession law particularly. And it really is down to the connecting factors, your subjective intention, and the surrounding circumstances showing a firm intention to remain in a jurisdiction permanently. And that's generally what domicile tends to mean.
Okay, thanks, Zach. Let's continue with the first case. This one final comment. Rudy and Katrina have one son, Kevin, who is an Indonesian citizen. If you show the next slide, Zach. Kevin is an Indonesian citizen, Singapore PR, and his domicile is in Singapore. There's one daughter, Katrina, who is in the US. You see all the assets of the couple in Hong Kong, in the US, and the BVI. Can we go on to the next one? Next slide, please, Zach. Yep. Okay. Let me first focus on the community property, community issue. Freddie, before we zoom into some of the features of community issues affecting an Indonesian marriage, could you briefly explain the what the term community actually means, and then elaborate on the basics of Indonesian community property rules?
Okay, thank you, Joe. So I think before we start with what is a community, better we start with what kind of law applicable to the Indonesian individuals. In Indonesia, that when we talk about the regulation on the individual relating to the marriage and inheritance, that's affected by his or her religion or his or her ethnic. So because in Indonesia we have several regulation on different type of religion for the personal matters like marriage and inheritance. So in this case, we would like to only focus on the regulation based on the civil code that we and the marriage law on 1974. So this is to make it more focus on this particular law. So now we start in the community. So basically, any single spouse that married and they do not sign any prenup or postnup agreement, so the assets post married would be constituting as a joint property or community assets or community property here. So that's the basic or the fundamentals idea. So unless they sign the prenuptial that govern otherwise, all assets after the marriage become jointly owned.
Okay, thank you. So do the Indonesian community property rules apply to inherited property of one of the husband or the wife, or do they do they apply to the property that was already acquired before the marriage?
Okay, basically the community property apply, of course, after for the inheritance as well. So let's say the husband passed away and the husband has an asset, let's say 100. So we need to take out first the portion of the community property. Let's say the community property, let's say 50. So the inheritance only on the remaining 50.
Okay. You mentioned a prenuptial agreement. Could you, just for those non-lawyers among us, could you briefly explain what a prenuptial agreement is?
Okay.
Whether it's legally effective?
Of course, thank you. The prenuptial agreement, yes, that's fully recognized in Indonesia and start governed since 1974. So basically, this is the agreement between the spouse. They sign before and start applicable as of the marriage valid by the law. This is something that the agreement that will govern how the ownership of the assets after their marriage. So anything they already have before their marriage, not subject to this, basically not subject to this prenuptial agreement. In 2015, the Indonesian Constitutional Court issued a decision to give an opportunity for the post agreement.
And that's basically the same as the prenuptial, but for those couples who never signed a prenuptial agreement. Okay, let's go on to the next questions. Freddy, can Karina claim community rights over property that has been transferred to a foreign trust, like in this case the Hong Kong trust that you can see on the top right?
Okay, so basically the spouse that not excluded based on the prenuptial agreement, they have the 50% of the other spouse assets. That's the basic principle. So the asset that transfer to the trust, for instance, the asset is cash in bank in, let's say, in Singapore and transfer to the trust, and this one, and then they got divorced, for instance, and what happened with the assets that's in under the control or possession of the trust? Yes, this one can be disputed or can be would be subject to the community property.
Okay, clear. And Zach, question for you: does the Hong Kong trust law give any protection against a community property claim?
Generally, Hong Kong would follow the sort of common law system, and within common law systems, although we generally don't have community property, so it's the same in Singapore, UK, Australia, etc. We do respect community property from a foreign jurisdiction. So from the Hong Kong trust perspective, you would look at whether or not Hong Kong had any applicable firewall legislation to defeat a sort of spouse's claim to half the assets transferred into the trust. Generally, well, in Hong Kong, there is no firewall protection against community. And it's probably worth mentioning that generally the international financial centers that do have advanced trust laws, they generally do not seek to defeat community property claims. And the basis of that is because community property really is a proprietary right by virtue of the effective marriage domicile. So it's not a sort of right that's been given by a discretionary court order. These are proprietary rights by virtue of the marriage domicile. And in this case, the marriage domicile would be Indonesia. It has community property, assets transferred into trust. effectively post the marriage or celebration of the marriage would be within the community, and therefore it would be a right that would be subsumed within the trust. So Hong Kong trust law doesn't provide protections against community property claims, and indeed many of the other jurisdictions, Cayman, etc., also do likewise. They don't seek to defeat proprietary claims against assets transferred into trust.
Thanks. And if you look at this particular case, the 75% indirect holdings of the trust in the Indonesian trading company, how would that be protected or respected?
I think this is, it's really down to if you can trace through the trust, which is what effectively I think Hong Kong will do. The question here is whether or not a sort of Indonesian court would short circuit all of that and seek to apply community directly against the proportionate share of the Indonesian trading company. I think for Freddie, this might be one for you, Freddie, is whether or not an Indonesian court would seek to disturb corporate structures in this way to recognize a personal right in Karina, let's assume, for her community property claim in assets that had been transferred into trust originally.
Yeah, I think the asset that transfer to the trust, including this example, let's say the trust indirect shares 75% in Indonesian trading company. When the transfer happen, the transfer should follow the community property relevant regulation that the wife should give the spouse consent, in short. So the transfer not in compliance or in absence of the spouse consent may be subject to the dispute or claim by the wife that 50% of that belong to the wife.
Right.
Thanks. We go on to the next, please. John, a question for you. Would the US recognize a foreign community property claim?
Yeah, thanks, Joe. I think the important thing to understand here is that the US treats these community property issues on a state-by-state basis, not federal, the way that the federal tax system works. Now, there is a separate state tax system, but there is an overarching federal tax system. There is not from a community property perspective. So absent a contention, absent someone challenging it, the answer to the question would be yes. The US would tend to respect the community property decision that has been reached by another jurisdiction, regardless of the state, tend to. If there's a contention, though, the states vary widely in their definitions of marital property, and they may not align with the Indonesian definition that's been achieved. So you might have a contentious issue. It's best to go ahead of time and identify the relevant jurisdictions where either property is located, like the land, immovable property, or property where it's temporarily movable, where you've got that bank account, maybe you shift it to a different state or outside of the US to avoid that conflict issue.
Okay, thanks. And Zach, what about the BVI? Do they recognize foreign community property ownership?
Yeah, so the BVI would apply UK common law principles. They would recognize the matrimonial domicile. And if the matrimonial domicile held community in property ownership, then the BVI law would respect that. So that they would look at the ownership of the BVI shares as being subject to whatever the community was in the source jurisdiction. So yes, I think for Karina in this case, were she to take an action in the BVI to recognize her community rights, then the BVI would apply UK normal common law principles. And a lot of these principles are quite old cases, old and dated cases. So they hark back to different eras, but generally they're consistent. And even though some of these cases look at the community property rights also extending not only to movables like a share, but also to immovables like land. And so there's a famous UK case with a South African couple where it also was found that the community property extended to UK land and not just to movable assets. So yes, the BVI would apply UK principles in the ordinary way, looking at the matrimonial domicile to recognize that.
Okay, thanks. Let's move on to the next case, a divorce between Rudy and Katrina. Next slide, please, Zach. Let's start with Freddie. Freddie, on what basis will the Indonesian court determine whether they have jurisdiction to grant a divorce?
Okay, so basically because the marriage was done under the Indonesian law, so or registered here at least, if they did the marriage under foreign law, so the Indonesian court would recognize the Indonesian marriage law, so they will accept the claim for the divorce and they start process and give the decision.
Okay, thank you. Would the Indonesian court try to redistribute or change the Indonesian community property rights?
Yes. Normally in the divorce claim, at least three main points to be there in the claim. Of course, number one is the divorce itself, by mentioning the reason. Number two, yes, about this community property. Number three, if they have children, the rights to take care of the children moving forward.
Okay. Would the Indonesian court follow and enforce the contents of a prenuptial agreement or postnuptial agreement?
In general, yes, they will check first whether the formality of the prenuptial or postnuptial already fully complied or perfected. Because it is quite common in Indonesia, the prenuptial, although the substance okay, but the formality somehow not really complied with. Same with the postnup. But the general answer, yes, they follow and enforce.
Okay, thank you. Next slide, please. Yep, thanks. Freddie, would the Indonesian court try to issue any order to change the ownership rights of the Hong Kong Trust, or would they try to terminate the Hong Kong Trust?
I think this depends on the situation, on what is the case by case, yeah. But in case the Hong Kong Trust involved in the transfer that not comply with the community property rules, the court may give the order that the transfer not correct, so the 50% of the transferred assets to the Hong Kong Trust would be still owned by the spouse that do not involve in that transfer, because the absence of the spouse consent.
Freddie, just on that, insofar as the Indonesian court is concerned, if we've got community property 50-50 to the spouses, and we've got a prenuptial or a nuptial agreement that basically respects that, it does other things, but it respects that their rights are 50-50. There's no chance of an Indonesian court making a discretionary order to disturb that 50-50 rule, is there? So they wouldn't just arbitrarily say that actually one spouse is entitled to 60% and the other is 40%, and then seek to dismantle foreign structures in order to achieve that division of property. Is that right? So they would generally respect the community and respect the prenuptial terms and wouldn't go beyond and try and make a discretionary order, disturbing those arrangements. Is that correct?
Yeah, okay. Generally they follow. The law give the opportunity for the third party actually who bound to this prenuptial, but they can prove the prenuptial or the postnup were made to cause damages to the third party. So the third party who suffer damages have an opportunity to submit the claim or debate or argue about the substance in the prenuptial.
Who would this third party be in practice?
Sorry?
Who would the third party be in practice that would challenge this?
In practice, to be honest, not really aware, or normally the court simply follow what stated in the prenuptial.
Yeah. Okay.
All right. So, a question probably for you, Zach and John. Would the Indonesian divorce court seek to make a discretionary order varying the rights to foreign property, like in this case the US and BVI? You want to go first, John?
Sure. Yeah, I think from a U.S. perspective, absent a contention, the movable property is more likely to really not face any challenge or any grabbing of jurisdiction. The immovable property, the land, it's a little tougher. You really would have to look at the state jurisdiction, and if you've got a conveyance of that runs contrary to the treatment in that state, and there is some contention in play, then yeah, you've got a problem that you probably, hopefully, took advice on ahead of time and try to resolve that before you get into a contentious situation. I'd like to mention just real briefly on the prenuptial agreement, if that involves this outcome here, if there's a prenup involved and the Indonesia divorce court is trying to rely on it to enforce, there's a few elevated standards we'd want to see from a U.S. perspective. So independent counsel for each party, full forthrightness, all assets and accounts were declared. If one spouse wasn't aware of some of the assets at the time of the prenup, that's a strong indication that that prenup could be invalidated and might not be enforceable. And then it shouldn't address things like child custody or duties within or after the marriage, because those won't be enforceable under a prenup. And then for the prenup, not for postnup obviously, but for the prenup, really want to see that about 5 to 6 weeks before the wedding, not the day of or a few days out from it.
From BVI perspective, I think, of course, BVI would probably be a matter of comity if BVI were to enforce a sort of foreign discretionary order dividing the BVI company. But I would have thought if, let's say in this case, Rudy remains in the jurisdiction of Indonesia, then the Indonesian court, if it were to make an order in this way, would have sanctions against Rudy in any event. And I think, Freddie, you could probably sort of confirm this, that if the Indonesian court were to make an order to Rudy to, let's say, transfer the shares or half of the shares in the BVI company, then if Rudy were to comply with that, then he'd effectively be in contempt of court and would probably be committed to prison if he didn't go on to do that. So it may not get to a point of enforcement in the BVI. Is that correct, Freddie?
Okay, for if Rudy did the transfer without the spouse consent and the spouse somehow claimed, two issues here. First, if the spouse think that this is a illegal transfer, so she thinks that the 50% belong to her, so she can claim first. On the civil law, so the meaning that the damages for the value of the assets. The second, if she thinks okay, maybe go to the criminal aspect, so the embezzlement may be considered.
Right, but if for whatever reason they wanted to transfer the BVI shares out of Rudy's sole ownership and also half of it, let's say, to Karina as part of the divorce settlement. If Rudy didn't comply with that order from the court, then he'd be in contempt, wouldn't he?
Yeah, I think if there is an Indonesian court order on that instruct Rudy to return, that's depend on how the decision speaks, because the instruction itself also need to be supported or back up with the confiscation. Confiscation order should be also there. So how the claim drafted very important here, to make sure that the decision is not only the declaration but also declaration plus the further action.
Right.
The further action meaning that's including the confiscation and then order the public auction and the proceeds given or transferred to the spouse.
Right. Okay.
Okay, thanks for that. Let's go move to the next case, the domestic succession. So Rudy passes away. Next one, please, Zach. Yeah. Freddie, I have a question for you here. On what basis do the Indonesian succession laws apply to Pak Rudy's inheritance?
Okay, thank you. So if Pak Rudy still keeps the Indonesian citizen, so meaning that the Indonesian succession law will be applicable. But this one again, like we discussed earlier, we need to honor as well the community property, because the community property should not be part of the inheritance assets.
Okay.
In terms of just the succession laws, we'll assume that Rudy is not within the Muslim faith. So how will the succession laws apply in that case if he's a non-Muslim?
Yeah, this is on the non-Muslim that basically the citizenship of Pak Rudy would play a very significant role here.
Okay.
So, yeah, the next question is on forced heirship. But let me split this in two. Can you first, Freddie, just briefly explain what forced heirship rights are? And then, do the Indonesian succession laws include forced heirship?
Okay, thank you. Basically, in Indonesia, we know that this type of concept, maybe the similar one is a legitimum porsi. So that the heir rights, let's say the kids, is protected up no less than 50% of their original rights. Let's say the kids supposed to have 30% or 40%. The rights can be reduced, but cannot be lower than 50% times the 30 or 40%.
Okay. So, okay, let's move on to one. Is it possible for forced heirs to basically agree that their forced heirship rights can be changed, or can they waive them altogether?
Okay. So of course, if they agree together and they agree to make their own calculation, that's possible. Let's say the kids supposed to have 30%, but agree to just have 10%. That's possible. Or sometimes the kids simply reject the entire inheritance, but the other kids agree to give him or her certain compensation. That's also possible.
Okay, that's respected. All right. The next question, does the Indonesian law, succession law, permit any testamentary freedom?
Testamentary freedom, yeah. This one is recognized, but still the testamentary freedom must honor or cannot breach the forced heir rights or legitimum porsi, and also cannot touch the matrimonial, the joint assets that are not subject to the inheritance.
So what's the percentage of the non-community property, so the free estate, what percentage can actually be disposed of by a will without any forced heirship right?
This one is not clearly regulated, but in short, everyone can do the testamentary, but the final calculation must be made and must honor the forced heir rights.
Okay.
Great. Let's move on here. Freddie, under the Indonesian succession law, is there a possibility for Rudy's heirs to claim back the asset that has been transferred to the Hong Kong Trust?
In general, yes, if the heirs do not or will not receive any benefit from that trust. In case the transfer breach the legitimum porsi.
Freddie, does it make a difference when the transfers were made into trust? I mean, this could have been many, many years before Rudy's death. Does it make a difference to the clawback when it occurred in terms of the gift into the trust?
In general, no such limit, but the basic statutory limitation for the civil code, basic statutory, not only about the clawback of this 30 years, the basic one, and then the clawback must be done no later than 3 years after the distribution.
Okay. So, what about the indirect holding of the trust in the Indonesian trading company? Is there any chance for them to claw back that holding?
Okay, this one is depend on the structure of the transaction, but in case the asset that transferred by Pak Rudy here is the shares in Indonesian trading company, so the shares in that Indonesian trading company may be subject to the clawback.
So in that way, the heirs can short circuit the Hong Kong Trust and just go directly against the domestic Indonesian company. Is that right, Freddie?
Sorry, can you repeat?
Is it possible that the heirs that want to do a clawback claim against the foreign trust, if they want, they can effectively go against the domestic Indonesian property and not bother to take a claim out in the Hong Kong courts? Is that right?
If the asset that Rudy transferred that to the trust is the Indonesian asset, yes. Let's say Pak Rudy own the shares in the Indonesian trading company and the shares transferred to the foreign trusts. And because of the transfer, the legitimum policy breach.
Right. But if instead he transferred money to the trust and the trust used that money to acquire shares in the Indonesian company, would that make a difference?
That's would be different because the assets which had been transferred is not the shares. So the transfer itself is the object of the.
Right. Okay.
All right.
So I think from the Hong Kong perspective, Joe, I can just answer, Hong Kong does have protections, as does Singapore, against heirship and succession rights in this way. So there would be some protections in the Hong Kong courts against the forced heirs being recognized. There'd be some preliminaries to go through with respect to sort of Rudy creating the trust during his lifetime, transferring the assets during his lifetime. And then there's some deemed rules on his capacity to do so, which generally allows that if he transferred assets, let's say under Hong Kong law, and they were lawful, then that would be fine. Rudy would be deemed to be a valid transfer of assets into the trust. So there are clawback, anti-clawback claim protections in Hong Kong, which would, in this instance, defeat or would likely defeat any claim being made to claw back through the Hong Kong trust.
Okay. And those rules in Singapore and Hong Kong are effectively, they work the same, right?
Yeah, in effect, the Singapore ones are a little bit older and they're a bit more prescribed because they effectively only apply to non-Singapore domiciliaries. The Hong Kong one's a bit more clearly expressed. I suspect it's the same draftsman that both rules are emanating from, but they pretty much follow the same principles. It's not a fully sort of comprehensive firewall because both Hong Kong and Singapore don't position themselves as aggressive international financial centers, but they will be sufficient to defeat this sort of claim.
Okay, thanks. Let's move over to John.
So
John,
from a succession perspective, I think important to also remember, like when we talked about marital property, this is a state-by-state determination. So we'd look to see, well, where are the company shares kept in the U.S. or outside the U.S. In which particular state are they kept or custodied in the banking relationship. So whether it's Indonesia or U.S., I think is first going to look at where that movable property is located. With the land, it's more about immovable property. So we look exactly where the land is located, and that state's succession rules. There will be federal estate tax complications arising from the land at a minimum, and most likely the stock, the shares as well. But there is a pretty simple, straightforward manner to address that and shield against the imposition of that U.S. estate tax, and that's holding those assets not in your own individual name as a non-U.S. person, but in an offshore company's name, and that shields against the imposition of the U.S. estate tax when Rudy passes away.
Well, John, just a matter of interest, John, when it comes to the succession to U.S. company shares, does the US apply effectively looking at the domicile of Rudy at death? Is that what they're looking at to make that determination?
Yeah, I think first of all, absent any contention and movable property, you're going to have a deference to that. Even with a contention and movable property versus immovable property, you're going to have maybe still I'd say maybe a slight deference to that, but you're bringing in the complication of a challenge that could be made under the actual location of where those shares are custodied. So we always want to see an individual in this situation with U.S. assets or U.S. heirs, have a chat with U.S. counsel, see if we need to look at separate wills, so that we're in a testate, not an intestate succession, or maybe we could combine wills, as long as we liaise with Indonesia counsel to make sure that we're not recommending anything that just gets invalidated by the primary location of the will.
Yeah, because presumably the Indonesian forced heir rules will be applied because of the movable assets. So it will be importing the Indonesian succession law rules, which will contain these forced heirship rights.
Yep.
Yeah.
And again, absent a contention, I think the U.S. would respect those. The U.S. doesn't have forced heirship in that regard. They have one state that's based on the civil law system, Louisiana, but back in the 80s, they kind of got rid of any of those concepts of forced heirship, even in Louisiana. There are statutory protections. They tend to fall more towards spouses, though, than any children protections in a protection concept for heirs.
Okay. So we move on to the next part.
Yeah, so from a BVI
BVI.
perspective, yeah, with succession law will apply. So BVI will apply usual common law principles. They'll look at the domicile of the individual at death. And in this case, that will be Indonesia. The BVI company shares are movable assets, so BVI would effectively apply Indonesian succession law. If you have a BVI will, which seeks to override the, let's say, the forced heir rules under the Indonesian succession law, then that would effectively not be effective. So it wouldn't be a sort of essential validity of that will wouldn't work. So it would have to comply with, and that's what BVI would do. It would defer to the Indonesian succession law. And if that succession law contains these forced heirship rules, then that's the way in which this property will pass. And whether they attempted a BVI will, or whether or not it was effectively a BVI intestate, these are movable assets and they would be subject to whatever Indonesian succession law provides. That would be the ordinary English principles being applied.
Excellent. Thanks. Let's move over to the next case about this very different case about Henry. Henry lives in the US. He has US domicile, but he always kept his Indonesian passport. This is a case that that you often see when Indonesian kids study in the US and decide to stay in the US and marry in the US. In our case on hand, Rudy is married to Vina, and they have 2 children. One daughter is in the US, and there's one son in Asia, in Indonesia. The son of Henry is Andri. He's Indonesian citizen, domiciled and resident in Indonesia. So let's can we go to the next ones? Foreign community property. Right, John. Question: how do the community property laws in the US work?
So sure. Just like we talked about on the first one, this is just a kind of a more in-depth toehold that the U.S. would have on these concepts. It's going to be done on a state-by-state basis, and each state, it can vary widely from the definition that, say, a California has of what is marital property and its community basis versus a definition of, say, a Texas or a Florida. So state-by-state analysis, but a stronger grasping of the situation because of the residency / domicile of the individuals involved. Whether it's going to apply to inherited and pre-marriage property, again, it's a state-by-state analysis. So it's highly important for Henry to take local advice as well as the federal tax advice and the connection with the outside jurisdiction. And those same points that I mentioned on pre and post nuptial agreements would apply here. We want to make sure they each have their independent counsel. They're fully forthright and disclosed everything. They don't put in elements of child custody and duties, and preferably like to see it a good 5-6 weeks before the marriage.
Thanks. And the how do the community property rights apply to inherited and free marriage property?
Sorry, John, just on the community, does it include inherited and pre-marriage property, or is it only just property during the marriage as a product of the labors of the relevant parties?
Yeah, I wish we could give a simple answer. I think that there are states, like I mentioned, like California, that can be quite aggressive in broadening that with a spouse that they see as either information was shielded from or in more of a need perspective, versus a state that's maybe a little more conservative than, say, like a Texas or a Florida, where they wouldn't have as expansive of a basis. So really is a state-by-state analysis, both from where they are resident and domiciled and where the property in question is located.
Okay. But Freddie,
Yeah.
as foreign community property ownership, is it recognized in Indonesia, like in this case?
Yeah. In this case, meaning that the assets located outside Indonesia belong to the deceased Pak Henry here, right?
Yep.
Yes. Subject to this one is we talk on the community property, yes, because depend on if he married under Indonesian law, the community property would be applicable. For the inheritance, yes, applicable here for Indonesia, applicable Indonesian law because Henry is still Indo citizen.
Right. And does it make any difference if the foreign marriage is or is not registered in Indonesia?
Yes, if the marriage done outside Indonesia and never registered here, meaning that the Indonesian law cannot regulate the community property because that's not Indonesian law marriage.
Okay.
Freddie, what would be the status of the couple? So they're Indonesian citizens. They've been married, they celebrated their marriage in the US, but they didn't register it in Indonesia. So from an Indonesian standpoint, what would they be? Unmarried?
From Indonesian perspective, they are married because they did not register here. The principle of valid marriage is if they marriage based on the if the marriage legal or valid under their religion. That's the basic principle. So for the marriage outside Indonesia, the requirements of the administrative registrations is mandatory. So if they married outside Indonesia and they never registered, even though maybe they married quite legally under the religion, but administratively that's pretty difficult to say that they married under Indonesian law.
Right. So therefore, the community property in Indonesia wouldn't be recognized if they don't have a registered Indonesian marriage.
Yes.
Right.
Okay. So Zach, is the U.S. community property ownership recognized and enforceable against the Singapore Trust in this case?
Yeah, the same thing again. It would be common law principles being applied as to whether or not the assets transferred into the trust were totally the ownership of, in this case, Henry. It would be, I think, a matter of sort of proprietary rights being recognized under the marriage domicile. And again, as I said, there's old UK authority on this. Singapore doesn't have any firewall protections that would defeat this proprietary ownership. And Singapore would look at the marriage domicile to see if it had community rights. So that would be, you would expect that there would be recognition of the community property transferring into trust. And presumably Vina didn't give any consent to that occurring, so it potentially could be a tracing claim as a result. Likewise with Cayman, they would again recognize the foreign marriage domicile and the rights that flow from that. But always with these sorts of cases, you would look at, particularly the one with Cayman, if Henry is within the jurisdiction. I think John can back me up on this, that if Henry is within the jurisdiction, then the US court can simply make an order directly against Henry to get the assets, and upon pain of contempt. Is that
correct?
John?
Yep, that's correct.
Okay, so I think that's the foreign element. I think that's Henry's fault. Okay, I think Joe may have broken up here. So
Can you guys still hear me?
Yep, there we go, Joe. Sorry, we just lost you for a sec. Go ahead.
I'm back. No, my internet was weak over here. Cool. There's some questions for John.
Yeah, so the divorce situation in the U.S. So now, unlike the original case study where the couple was outside of the U.S., if they're in the U.S., really is about in what state they're considered domicile resident. Again, each state has a slightly different definition. There's a tendency, though, to want to avoid to be seen as a divorce mill. So they wouldn't be extremely short periods of time, but they could be. It could be, a 6 to 8 week minimum period that you've been in that state before it attaches. Others may be more aggressive / conservative, depending upon how you're looking at it in claiming jurisdiction, and say, look, you got to be here for 6 months to a year before we would entertain that we have primary jurisdiction over this divorce matter. And then you'd also bring into play where the property is located, those same distinctions we've already spoken about, movable versus immovable property. Immovable, more likely to have the U.S. jurisdiction. Immovable, that is, movable property, maybe not, in a deference to a foreign judgment or order. And then same points that we've mentioned, they haven't changed in regard to the pre and post nuptial agreements and their effect on that divorce.
Okay, thank you. Yep, thank you, Zach. So, John, could the U.S. court order the Indonesian assets to be divided?
Yeah, so the typical, I would say, and I think Zach will speak a little bit more about divisions of property and variances of trust. The U.S. tends to shy away from this unless they're just left with no recourse. Sham transactions maybe, so if there was a transfer of that property, if it was movable property that was moved outside of the U.S. to Indonesia, if it wasn't immovable property, then they might try to invalidate the transaction itself. But ordering the specific division of something outside is not as likely, but it definitely is a possibility. And then whether the U.S. court order be recognized, again, I defer to Freddie on that.
Can you comment on that, Freddie? Would a U.S. court order be recognized in Indonesia?
Okay, basically all foreign court decision not recognized here. Parties have interest should relitigate or start from fresh the case in Indonesia court, and the decision from, let's say, U.S. court can be used as evidence, and expert opinion, let's say this involved is foreign law, should be provided as well to justify the argument. So that's the way if people want to enforce the foreign court judgment.
Okay, thank you. Move on to the next one. John, would the U.S. court seek to vary the terms of the Hong Kong trust or divide the Cayman company shares?
Yeah, similar answer that I already touched on. I think the first kind of the main focus of the U.S. court would be a sham transaction or sham trust issue and just invalidate the entirety of the structure, not so much vary it or try to tweak around the edges. That common law concept exists within the U.S. system. It's just not as commonly used by the courts, definitely less so than the UK, and I'm sure Zach can touch on that.
Yeah, I mean, from a Hong Kong perspective, there isn't any express firewall protections against the foreign matrimonial court order to vary or sort of declare the trust as sham, etc. Hong Kong, as well as, Singapore, in this case, Singapore doesn't have the protections, neither does Hong Kong. Both Singapore and Hong Kong have not adopted some of the more sort of robust protections that, let's say, jurisdictions like Gibraltar, Jersey, Guernsey, Cayman, BVI have adopted. So it is possible that the order seeking to vary the terms of the trust may be respected by a Singapore court, but it would really be as a matter of comity as to whether or not the court would do that. Certainly in other jurisdictions, I think the US is another one of these where there's no express firewall protections, but generally the courts will shy away from having foreign orders disrupting domestic trusts or domestic structures. That can be an approach adopted by the Singapore judiciary if it were to be a case. In Cayman Islands, they would again look at, because these are not money judgments, these are looking at transfers of assets. In many cases, they would look at comity as a basis to respect the foreign courts. And certainly if we had an instance where, let's say Henry was deliberately transferring assets out of the US to frustrate a US family court from discharging its obligations to the marriage, the dissolution of the marriage, then generally sister courts will not look favorably on individuals sort of abusing jurisdictions to try and hide assets where there's a foreign family court trying to do the right thing by the parties. So it would be a matter of comity. There's no express firewall protections with respect to the Singapore Trust against a foreign judgment where it's dealing with a matrimonial order. So there's no express protections. The only protections that Singapore has deals with succession and inheritance claims.
Thanks, Zach. Shall we move on to the foreign succession? So Henry passes away, leaves behind Vina, Grace, and Andre. John, what's the basis for US succession laws to apply here?
Yeah, so from a federal perspective, all US citizens are considered to be domiciled in the US regardless of their location. Henry does happen to be physically in the US. We look at a state level analysis to figure out again which succession rules apply, and then the succession law that will apply to the US company shares. There's an opportunity here in all of these questions to kind of pre-plan. So we have a distinction between testate and intestate succession. Hopefully Henry's taken good advice, he's got a will in place, and so he has a good amount of decision-making authority over resolving any conflicts of laws from different jurisdictions that might potentially claim jurisdiction over the property that he's going to be passing. And if he does that in a will, that'll clear that up before he passes. If he doesn't, we're under different intestate succession laws and how they define the property that they have jurisdiction over. And then forced heirship we touched on earlier. Don't really have that concept. Some statutory protections for a spouse maybe, but not really anything that would mandate something to go to the children.
Thanks.
The US wouldn't follow the citizenship of the deceased, would it? He's still an Indonesian citizen. Would it apply Indonesian law because he's a national of that country, or what would it just apply his residency status in the US?
Yeah, it would not impact the US determination, but there may be an outside impact, and then we'd want to look at whether there are estate tax treaties in place. In this instance, there is not. And so you're going to want to be very careful from an executor perspective about how you go about paying the relevant taxes. So if Indonesia were to have some claim, and I'll let Freddie speak to that, but let's say, for example, case that they did, you would want to make sure that was that you timed the credits sideways, because the US isn't going to give that credit for foreign taxes paid. Indonesia might. So you want to settle the US side first and then claim the credit, because if you do it the opposite direction, you might end up in a double tax situation that you otherwise could have avoided, and you either spend time claiming back or you won't be able to claim back.
Thank you. Freddie.
Yes.
Would US or Indonesian succession laws apply to the Indonesian property of Henry?
I think this for the illustration of the case here, Pak Henry still hold Indonesian citizen and Pak Henry has Indonesian asset. From Indonesian law perspective, the inheritance should follow the Indonesian law.
Sorry, would the US or any foreign forced heirship rights be effective over the Indonesian property?
So
I
this is,
don't think so, because the Indonesian law should be upheld in this case in the event Pak Henry passes away and still holds Indonesian citizen. And this is the Indonesian property anyway, so it's impossible to enforce the foreign law decision, which may have different opinion, but the forced heir rights under Indonesian law still applicable in case any breach of the forced heir rights in the distribution.
Okay, unless the marriage, the U.S. marriage wasn't registered in Indonesia, right?
If they didn't register, let's say Grace or Andre, they become the so-called illegitimate children. So they need to have the court order first by submitting various supporting documents to have a declaration decision that they are the legitimate one, the legitimate child. And then after that, they can have the protection of the forced heir rights here, meaning that they do the two steps action before they get the forced heir rights.
Yeah.
what about Vina, the wife? If the foreign marriage wasn't registered in Indonesia, what's the status of Vina as a forced heir? Is she still a forced heir, the surviving wife?
Yeah, because administrative issue here, Vina cannot be considered as the wife for the purpose of the under Indonesian marriage law, because not registered yet.
All right.
So very difficult for her to pursue the rights community property. Yeah, but if she has benefit from the testament given by Henry, assuming that Henry gives the testament, Vina can pursue the rights under the testament as one of the heir.
Right. Yeah, well, she just wouldn't have the forced heir rights because she's be viewed as unmarried. That's
Yes.
Yeah. Okay.
All right. Let's move to the next one, please. Okay, Zach, this one's for you. Can the Indonesian forced heirship rules and clawback rights be exercised against the trust in Singapore?
Yeah, so Singapore, like Hong Kong, has the ordinary anti-forced heir provisions. It would all be down to, I mean, in this case, we're saying that Henry's US domicile at death. The key thing on the Singapore side for the protections is that at no time was Henry a Singapore domiciliary, either at the creation or the later transfer of assets into this trust, and assuming the fact pattern that he had no connection with Singapore, then the anti-forced heirship provisions under the Singapore Trustee Act would apply in the usual way to defeat a forced heir claim. And then with respect to the succession law, which succession law will apply to Cayman company shares, Indonesia or US? Now that would be a matter for Cayman Islands to determine, applying its own forum rules. And what they would say is they would look at the domicile at death. Under Cayman law, they would look at Henry's connection to the US. And I think in this instance, they would accept that Henry died a US domiciliary, and therefore succession to the company shares in Cayman Islands is governed by US succession law and not Indonesian forced heir rules. Because Cayman Islands, like the US, a common law jurisdiction, and they would look to domicile and not nationality at death for the applicable law to be applied to which heirs can get the shares to the company. So it would be US law that would be applied to the Cayman company shares.
Thanks, Zach. Let's move on to the third case, something I hear a lot lately. We have an Indonesian couple, Agus and Elsa, with one child, Ansel. So Agus and Elsa are intending to migrate to Europe. So now I want to hand over to Dominic and basically just for a start give us some a rundown on the popular European programs, the process to apply, and the due diligence process.
Thanks, Joe. Yeah, so maybe, so what we're talking about here, of course, is investment migration. So we're getting a lot of interest out of Indonesia, particularly looking at what a lot of high net worth individuals there consider to be their plan B, or sort of more of an insurance policy, against anything, against economic uncertainty, political uncertainty. Very few of our clients actually use these investment migration programs and leave Indonesia. But certainly they're using them for a myriad of other reasons around, the children's education. Of course, now with COVID-19, the ability to get access to better healthcare systems, and other things like that. So Europe is very often a focus for them. The great thing about Europe, if you just, I think, pop over to the next slide, the great thing about Europe is that it has a mix of both citizenship by investment and residence by investment. So these are, as you can see on this slide here, there's a lot of countries around the world that now have these investment migration programs. So probably over 100 countries now have some form of legislation or regulation in place, but only really these 30 odd here have very active and relevant and attractive programs that are very much taken advantage of by financially independent people. So Europe is often the focus, particularly in a place like Indonesia. The US, of course, is also very popular, and I think a lot of wealthy families educate their children in the US. We speak to a lot of clients that like to do this through an investment migration program and not necessarily just with a student visa, because it's actually more beneficial. In Europe, as I said, that this is the countries we see here is a bit of a mix. So Austria, Cyprus, and Malta, which you can see on the screen. I would say those would be sort of the top shelf options. These three countries, it's possible through a significant investment or sometimes contribution to the country to acquire citizenship in those countries. So Austria, Cyprus, and Malta, particularly attractive because they are all members of the European Union. So you don't have to go to, you don't have to go and live in the country. You don't have to learn the local language. As long as you have the financial capacity and, coming to the due diligence and AML checks. Of course, this is only for people, that can pass the very thorough vetting and due diligence processes that these governments perform. But with a multi-Cypriot or Austrian citizenship, you basically have access to the whole of Europe. So you are then a European citizen. You have settlement freedom across Europe. Your kids can go and study for free in Sweden. They can go and get work experience in Germany without ever having to worry about a visa. So the citizenship is very attractive. Of course, as an Indonesian national, you're not allowed dual citizenship. So this is a consideration that the family will have to be comfortable with, that if they acquire an alternative citizenship, they would have to, surrender or renounce the Indonesian citizenship. So that's arguably an easier decision for someone that's already maybe a permanent residence in Singapore and has sort of handed over the business in Indonesia to the next generation. Other families we work with, only certain individuals within the family would look to take the citizenship. But the nice thing, as I said, about Europe, and which is very popular in Indonesia, is the residence by investment program. So there, at the front end, you've got Portugal, which has a very attractive golden residence permit program. Greece has a similar program, and these are typically real estate investments anywhere from 250 to 500,000 euros. You're getting the Plan B, you're getting residents in these countries. Both have reacted incredibly well in terms of their sort of pandemic response now and how their healthcare systems have coped. And critical for a lot of our clients is because countries like Portugal and Greece are in the Schengen zone, just by acquiring real estate and getting a resident permit for that country, you would never have to worry about a Schengen visa again. So you're getting actual, global mobility and access to the European Schengen zone just by having that residence permit. So I'd say those are probably the most popular in terms of Europe. Of course, we do have lots of clients as well from Indonesia that are looking at places like Australia and New Zealand, also have interesting investor visa categories, as well as the UK. So that would probably be in a nutshell there. If you just go back to the other slide, just so I'm making sure I'm hitting all the points. In terms of the application process, obviously, we would make it as sort of straightforward and easy for the client as possible. So, as I said, the due diligence is very important. There's a sort of onboarding process, and then the governments would certainly do their own enhanced due diligence on these individuals. On the investment amounts, as I said, on the residence by investment, Greece, 250,000 euros into real estate, which of course you can rent out, so that's interesting. Portugal, usually about 350 to 500,000 euros. And then if you look at the sort of Malta, Cyprus, Austria categories, because those are citizenship and settlement freedom throughout Europe, they do demand a higher capital outlay. So Malta's about €1 million, Cyprus probably all in about 2.4 million euro. And they will range anywhere from 3 to 8 million euro, depending on whether the client wants to go the donation route, which is available, or an investment into a company. Finally, the AML due diligence, as I said, these programs are quite strict on this now. Well, have always been very strict, but tightened it even more now in terms of really understanding the client's source of funds. They want to know, if you look at Malta, you've got to disclose what is your net worth, where are those assets sitting, how did you acquire the funds to acquire those assets, and of course the due diligence procedure is now very much part of the process, and largely done by the government that they're applying to.
Thank you. What quick question, Dominic? A ballpark figure, how long does it take to, suppose you plan to be out of Indonesia in, let's say, the next so many years. You plan for what? Is it a 1 or 2 year process to?
Yeah, so it would depend on the country. In Greece, you can get permanent residence. Greece, if we start today, probably the whole process probably takes no more than 3 or 4 months. Malta would be a longer process, probably about 1.5 years from start to finish. But although it's a longer process, you get the residence of Malta within probably the first sort of 1 to 2 months. And so you could already move to Malta. And then it's just a case of waiting for the government to finish their citizenship processing. So all in all, the Malta citizenship and passport is about 1.5 years, but you do get the residence very early on. Portugal probably takes about 5 to 6 months. Cyprus now probably 8 to 10 months. So it's usually a sort of roughly a 6 to 12 month horizon that the family can plan for.
That seems to be that's fairly quick. All right, thanks a lot for that. Maybe we have time for 1 or 2 questions from the audience.
I got one with respect to the Singapore Section 90, and just mentioning whether or not Section 90 is wide enough to defeat a community claim, because Section 90 seeks to validate the capacity to transfer into trust. I think it's important to note that Section 90 is geared towards inheritance and succession, not to matrimonial regimes. So it's not geared up to protect against that, even though it validates the capacity to transfer. That capacity that it's discussing is the capacity with respect to transferring to defeat a forced heir or a succession claim. it's not broad enough to capture matrimonial, which is completely separate from a succession standpoint. So one's succession law and one's matrimonial law, and Section 90 is not dealing with matrimonial law when it seeks to validate the capacity of a person to transfer an asset into trust. And there's another point there from another participant dealing with Muslim and Sharia law. I think the best answer to that is there will be, we will revisit some of these things, but we will be dealing with it from a Muslim marriage perspective. And I think that's probably better dealt with under that. At the moment today, yeah, the Indonesian law that we're discussing is really the Dutch ancestral sort of legal system that applied during the colonial times that still is applicable in Indonesia now. And with respect to, I have another one, which is, I think this is an interesting one for sort of Freddie. Insofar as, and I think we could just encapsulate this all. Freddie, if we just take a communal garden instance of an Indonesian passing away, and then you correct me if I'm wrong in any of this, the first thing that will happen is you'll get a separation of the property that the deceased held at death into half of which, under the general rules, will go by community to the surviving spouse. So that's an automatic transfer. Then you'll have the other half that's remaining, and it's this that will then start to be split between the surviving spouse and the children of the marriage. And then there'll be a portion left, which is disposable, which is the portion that the deceased could, by will, transfer to anyone he wishes. Is that basically how it is? So you split community, then you go forced heir, split between forced heirs, and then there's a hanging bit at the end that you can actually have free disposition over. Is that pretty correct?
Yes, generally correct, yeah. But on the forced heirs, that's basically you need to put in priority, or we need to take care first where after the community property.
Yeah. So
let's say using the figures 100. So the first 50 community property, so nobody touch unless the surviving spouse. The remaining 50, we make sure the 25 protected for forced heir rights.
Right.
After that, the other 25 can go to the heir.
Right.
Or if any testament or whatever, we can deal later. Meaning that we can be a bit relaxed to see the remaining 25.
Right. And just, Freddie, on the computation of the estate value, when you're working out whether or not the heirship rights have been breached, is it right that you basically compute the entire estate during the lifetime of the deceased? So giving away gifts during their lifetime, they're all brought back in to the pot to make up the actual estate notional value at death. Is that correct?
General, yes. The issue is about valuation. Let's say if we use Pak Rudy here as the first sample, the first illustration, when he passed away, let's say he was 80. So during his life, he already gave the son land, maybe the other one is shares, but the valuation may be a bit different when he passed away. So that's something that sometimes the tension during the distributions comes up.
Right.
The valuation may be already much different than the one that may be stated in the deed of grant.
Right. Right.
So that's a quite classic issue for the clawback or for the computation of what already given or granted in the past.
Right. Right. Okay, I think that's pretty much all of the relevant questions that we've got. I think we probably can wrap up there. It's actually 6 o'clock on the dot.
Yep.
For Singapore time. The recording for this session will be made available once it's uploaded to the cloud. And members can then, if you've registered, you should go on and be able to sort of view that on demand without any further requirement. So I think we're probably going to call it a halt now. Tomorrow is the China virtual roundtable, and later on in June will be the Thai as well as the Malaysian versions of this. And the dates for those will be confirmed once they are available. If there's further questions, please feel free to send me an email with questions on this or any of the others. I've got, in terms of the slides, if you wish to have them, they have all of the relevant speakers as well as their email addresses. So if you've got any further questions, then please send them along, and then we'll endeavor to give you an answer. Okay, I think that's pretty much it for today. Thanks very much for attending this virtual roundtable, and I think we call it halt today. Thank you. Thanks to all the panelists.
Yeah.
Thanks, everyone.
you.
Thank you very much.